United States Constitution to overturn the ruling and to make clear that corporations are not people with constitutional rights. And I'm honored to be here tonight with all of you. I'm thrilled to hear all these reports from the class of set of workshops. It's inspiring to hear all the ideas of Occupy Boston and all that needs to be done on a variety of questions facing our democracy today. I'm certainly honored to be on this panel to discuss this critical question of whether or not corporations should be treated as people under the Constitution. This question of corporate personhood, as some of you may know, dates back to a ruling in 1886 where the Supreme Court effectively found that corporations can be treated as people under the 14th Amendment to the Constitution. And that case was actually not decided on that question. It was in the head notes. It was written by a clerk to the court who happened to be a former railroad executive. So the court actually never even said that in the case, but that falsehood, if you will, has been brought all the way to today on this notion of corporations being treated as people. There was a period of time where it was elevated after that ruling in other cases, and then it remained dormant for quite some time after the New Deal era, and was resurrected in the 1970s by a then private attorney named Lewis Powell, who was writing for the Chamber of Commerce. He was an attorney consulting for the Chamber of Commerce at the time, and they had asked him to come up with a strategy to deal with the growing set of public interest laws that were being passed in that era, on the environmental front, on the civil rights front, on the consumer rights front, on the health care front. And so he wrote this infamous memorandum, the Powell Memorandum, that was not designed to ever see the light of day. It was a secret memorandum to the Chamber of Commerce. And in that memorandum, he articulated this notion that corporate America could come in to the federal courts, could come into the U.S. Supreme Court, and effectively argue that they have free speech rights under the First Amendment, corporate speech rights that need to be upheld in the face of all these laws. And then Lewis Powell, as some of you may know, became Justice Lewis Powell, nominated by then President Nixon, confirmed to the court by the U.S. Senate, and he became an architect of this doctrine, of this corporate rights doctrine, corporate speech. And so the notion of corporate personhood was resurrected via this Powell doctrine. For the past 30 years, we've seen this erosion of our First Amendment and our Constitution as a result, where environmental laws, health care laws, consumer rights laws, public interest laws enacted by we the people through our elected representatives at the federal or state level have been struck down on this falsehood of corporate speech. And just to give you an example, on the road to Citizens United, of the kind of cases that were decided, here's just one example out of the state of Vermont. I heard this report dealing with organic farms and the Monsanto company, and I was very interested to hear all the ideas coming out of there. As many of you may know, Monsanto developed a drug known as the bovine growth hormone drug that was designed, arguably, to increase the efficiency in milk production. The problem is, as many of you also know, there are serious health impacts of the use of this drug in milk production, both on animals and on humans. And as a result, people throughout the world work to ban the use of this drug. Australia banned it. Europe banned it. Large parts of the world banned the use of this Monsanto drug. But in the United States, the Federal Drug Administration fast-tracked the use of this drug because of the power of the corporate lobby and the industrial dairy lobby. And so what you had was the use of this drug now throughout the United States in the 1990s. And during that time, the state of Vermont decided, well, we're at least going to, if we can't ban the use of this drug, we're going to require, that people have to label, the dairies using this drug have to label whether or not they're using this drug, so people can make a choice. when they're buying milk. Whether they want to buy milk from a dairy using a Monsanto developed drug, or whether they want to buy milk from an organic dairy. That was the idea. It was a strict labeling law, disclose whether or not you're using the drug. And the state of Vermont passed that law through a citizen legislature signed by the governor. And then the Industrial Dairy Association went after the state of Vermont in federal court. They filed a lawsuit. They said, we have a corporate speech right here that's being infringed. We have the right not to put these labels on our products. That's a violation of our right not to be forced by the government to say something. And they got into federal court on this question, and they got up to the Federal Appeals Court at Second Circuit Court of Appeals, and they won. They got that law struck down on this corporate speech argument. So now we've taken the First Amendment and we've turned it on its head. It's not being used to protect we the people and our right to speak or not to be forced to speak by the government. And now it's being used to protect corporate America and their right to hide critical information that is designed to protect human health and animal health. This is crazy. This is an outrage. And on the road to Citizens United, this is the kind of result we've seen with this corporate rights doctrine. We know in this room that corporations are not people. They do not breathe, they do not think, they do not have a conscience. In fact, they have state-based advantages that you and I do not have. Limited liability, perpetual life, the ability to aggregate wealth and distribute wealth. And for those reasons, the framers understood that corporations should not be treated as people under the Constitution. James Madison spoke of corporations as, quote, a necessary evil subject to proper limitations and guards. Thomas Jefferson hoped to, quote, crush in its birth the aristocracy of our money corporations. And for two centuries, the federal courts and the U.S. Supreme Court followed that mandate under the First Amendment until the Powell Doctrine. And then we got to the Citizens United ruling, the most extreme extension of this doctrine, where corporations are now allowed to invade the political sphere with a so-called political speech right to spend their general treasury funds in our elections. Now, we know the problem of money in politics existed before Citizens United. And, you know, many in this room, I know, have worked on this question. I'm proud to have worked with many of you on this question of the problem of money in politics and pushing for public funding of elections here in this state. But this decision of Citizens United created a landscape change in our system of campaign finance, because now we've not only had the problem of bundled money from wealthy individuals and bundled interests putting together that kind of campaign war chest, but now we have the ability of corporations themselves to be able to spend their general treasury funds. So in 2008, to give you an example on this, the total amount of money spent in our elections by the Obama administration, by the Obama campaign, McCain campaign, congressional campaign, political parties, PACs, all of that money combined in 2008 was $5 billion approximately. Huge amount of money. Enormous sum. But imagine for the moment that the top Fortune 100 companies would have spent their general treasury funds as they now can do in the next presidential election cycle. The top Fortune 100 companies in 2008 alone made $600 billion in profits. $600 billion. If they had spent just 2% of their profits that year in the 2008 cycle, they would have more than doubled all the amount of money combined spent by the Obama, McCain campaigns, the congressional campaigns, the PACs, the parties. That is the threat posed by Citizens United directly to the integrity of our elections and our democracy. And it is why we need a constitutional amendment to overturn the ruling, to overturn the corporate rights doctrine, and to make clear that we the people rule, not we the corporations. That is the fight on our hands. There is a growing